Well, Wrigley company had won. I did a video of this about a couple months ago or so, about a month, maybe a month ago, in regards to Wrigley suing a e-liquid company for trademark infringement, and they did not answer the complaint, and therefore there was a judgment by default entered against the defendant or the e-liquid company. And now they have to not so much answer to Wrigley, they have to answer to the court. And if they don't answer to the court, then they will be in contempt of court, which is a whole other ball game now. So as you can see, this is entered on April 12th of 2018, which was last Thursday. This case number Zoom is kind of weird. Okay, let's just do that. Case number 1:18-CV-00642 in the United States District Court for the Northern District of Illinois' Eastern Division. W.M. Wrigley Jr. Company plaintiff versus Get Wrecked Juices Limited Liability Company and Brian Edward Turner defendants. Judgment. Pursuant to the court's order granting the motion of plaintiff W.M. Wrigley Jr. Company, or Wrigley, for a default judgment pursuant to Rule 55B of the Federal Rules of Civil Procedure against defendants Get Wrecked Juices or Get Wrecked and Brian Edward Turner or Turner. It is hereby ordered and adjudged and decreed that judgment be entered in favor of plaintiff Wrigley and against defendants Get Wrecked and Turner on Wrigley's complaint. Defendants have violated the Lanham Act of 15 United States Code 1114 and 1125, the Illinois Uniform Deceptive Trade Practices Act, and Illinois common law, and such violations were willful, intentional, and deliberate, making this an exceptional case under 15 United States Code 117A. Defendants, the respective officers, agents, servants, employees, attorneys, and all others in active concert or participation with any of them, are permanently enjoined from using Wrigley's Starburst mark and trade dress, Wrigley's Skittles mark and trade dress, any other trademarks or trade dress owned by Wrigley, or any colorable imitation or simulation of them, including Skittles, in connection with any products, including offering for sale any products using such trademarks or trade dress, including on websites owned by defendants or any of their affiliates, or on any social media platforms owned by defendants or the affiliates, or in any physical locations. Doing any act or thing likely to induce the belief that defendants' products are in any way legitimately connected with or sponsored or approved by Wrigley, and doing any act or thing that is likely to dilute the distinctiveness of the Wrigley Starburst mark and trade dress, Wrigley's Skittles mark and trade dress, any other trademarks or trade dress owned by Wrigley, or that is likely to tarnish the goodwill associated with such marks and trade dress, including the use of Skittles. Defendants, the respective officers, agents, servants, employees, attorneys, and all others in active concert or participation with any of them shall immediately recall from all distribution channels all products, packaging, advertising, and promotional materials bearing or infringing on Wrigley Starburst, and you see what it says, immediately delivered to Wrigley for destruction from all distribution channels, all products, packaging, advertising, and promotional materials. And you see what it says. File with this court. This is very important. I would hate to have be in contempt of the court, but it says file with this court and serve on Wrigley a report in writing under oath within 30 days of the entry of judgment, setting forth in detail the manner and form in which defendants have complied with the terms of any injunction entered by this court, meaning what I just read above, that they have to stop selling anything in regards to Wrigley's products and destroying or immediately deliver these products to Wrigley. That's not just nationally. It's not just the United States markets, internationally, all over the world. They have to recall all of their products. So it says, which defendants have complied with the terms of any injunction entered by this court. Wrigley shall recover its costs pursuant to from defendants jointly and severally, subject to a bill of costs pursuant to, meaning the cost of following this whole case. Wrigley shall recover its attorney's fees, meaning the attorneys get their fees paid by a defendant. It was entered on April 12, 2018 by Honorable John Z. Lee, United States District Court for the Northern District of Illinois. So now they have to answer to the court. Before they just had to answer to the defendant. I mean, the defendant had to answer to the plaintiff. Now the defendant, that is Get Wrecked and Mr. Turner, has to answer to the court. This is very important. And if they don't answer to the court within 30 days from April 12th of 2018, then they are in contempt of court, and then they'll probably be thrown in jail until they actually respond to the court and to the plaintiff, meaning Wrigley, with the information that is contained in these particular sentences here. Very interesting stuff. Now, you know, I was going to sort of let this one go because, you know, but I wasn't going to do a video of it. Do It Yourself or Die is going to have a live show on this later on today. I'm sure he's not going to pull up this document. Maybe he will. I don't know. But I thought it would be like a part 2 to what I did like a couple months ago. Do It Yourself or Die has more of a reach, so he can maybe get this information out there. Hopefully he does it without putting any misinformation. Probably you won't put any misinformation out. And it puts it in perspective so people understand it. What's going on here is about a trademark violation. And the main reason why I did this was you hear so many things about labels and, you know, white lists and black lists and purple rainbow lists and pink lists and all kinds of lists. And you hear all kinds of things about, I don't know, you know, caffeine bought in bulk. Not that I buy caffeine in bulk. I don't think anyone really buys in bulk. I mean, bulk could mean, you know, a lot of caffeine, or a lot, in our particular case, be a lot, a bulk, like maybe, what, 100-gallon drum or whatever of nicotine. No, whatever is put out there normally is not true. Anyway, that's beside the case, at least the little research that I did on this whole concept of the caffeine bought in bulk. In bulk. Not if you want to buy a little bottle of caffeine or nicotine, but in bulk. Anyway, the point is people are so caught up in the labels and everything. And this is what really matters. What really matters is trademark violations, copyright violations, patent violations. You don't see the FDA. You don't see any of the states, all the states in America, sue particular e-liquid companies or vape companies or manufacturers in regards to labels. You don't see that. You don't see that. Name one case Since Judge Mehta's case back in August of 2016 and regarding labels, name one case on a state level, local level, or federal level that the FDA had taken to court over a label. Name one case. I dare you. I dare you. You can't find them. They don't exist. Not after August 8th. Not after August 2016. I believe the date was like August 5th of 2016 or August 15th of 2016, somewhere in there. Judge Mehta's decision. It's MEHTA, a United States District Court judge. What you do see, and this is just one company being sued. The juice box e-liquid company is also being sued by the company who holds the trademark on that. That's currently going on. You really don't have a leg to stand up on when you're being sued, especially by these huge companies that have been around for over 100 years. I mean, Wrigley. How old is Wrigley? See if I pull that up real quick. These guys, man, just don't see it for what it is. They've been around since 1891. 1891, Wrigley Company. You know what kind of money they have? I don't want to be messing around with these guys. So what I was making the point is, you'll see huge companies like Wrigley's take e-liquid companies or vape companies or hardware or software or whatever have you to court because they own a trademark or a copyright or patent on their particular product. It doesn't matter what it looks like in terms of, is it childish, a child appealing, or any of that shit. Excuse my language. Has nothing to do with that. It has to do with simply that Wrigley owns a trademark on Get Wrecked e-liquid labels, period. They own the image. And you can't slice, dice, and splice it. You can't call things, instead of calling it, the original name is Skittles, and then call it Skittlies. You can't do it. Sorry, can't. And anyone, you and I even, can file for a patent or copyright or trademark claim or right with the United States Trademark and Patent Office. You and I could do that. It costs you a little money, and there's a process you have to go through. But you certainly can do that. So let's say, for instance, hypothetically, it's too late now, of course, but let's say Get Wrecked decided to say, okay, let's put Skittlies through the trademark search at the United States Trademark and Patent Office. Let's take a look. So what comes up for Skittlies. And if you put Skittlies in the search box and Skittles comes up, guess what? Hands off. It's too close. It's way too close to this. Then if you put if it's possible, I don't know how they could do this, but if you could put the imagery of what Skittlies looks like as opposed to Skittles and do a search on it, I'm sure the Skittlies is going to come up looking like the Skittles. And not only that, by then, I mean, it's pretty simple, When they enter a default judgment, what basically is saying is that the defendant has no leg to stand up on. Why incriminate yourself even more by answering the complaint? In other words, you're saying, I am wrong. I wash my hands of it. On the liability aspect, well, there's two parts to a civil lawsuit. One is liability. Can you prove liability? Who's at fault here? Well, Wrigley's definitely proved that Get Wrecked, or Mr. Turner, is definitely at fault. So they proved their liability phase. Now it's a question of damages, and that's where all this stuff comes into play. Immediately recall from all distribution channels all products, packaging, advertising, promotional materials. This is around the world, not just America, around the world. Immediately delivered to Wrigley for destruction from all distribution channels. And they do this in every case. This is how most of this, the redress is. And then the big whammy is file with this court, serve on Wrigley, or give them a copy to Wrigley, but mainly they're following with the court, a report in writing under oath within 30 days of the entry of judgment, meaning April 12th, 2000. So by like around May 12th of 2018, they're still not off the hook. They're way off the hook. Get Wrecked is still way off the hook. Setting forth in detail the manner and form in which defendants complied with the terms of any injunction entered by this court. And those injunctions is up here. The immediate recall, immediately deliver. They can't sell that product anymore. In fact, they have to take all those products from in America as well as around the world and deliver them to Wrigley. And I'm sure they're going to have to deliver it to them certified. And in fact, if they don't, either certified or by a truck. Yeah. Every single item will be pulled from the shelves. What could happen? What could happen is Get Wrecked declares bankruptcy. They could do that. They still have to answer to this court, but they could, if they immediately file for bankruptcy, they could say, we filed for bankruptcy. That is an estoppel in a sense, and that is, it stops the process that's going on in this particular court until that court, the bankruptcy court, hears the case, finishes it all up. And then I'm sure part of the judgment in the bankruptcy is whatever monies that Get Wrecked does have will go to Wrigley or satisfy this particular court in regards to Wrigley. So the only rule out is to file for bankruptcy. Absolutely. Either Turner, I don't know how he has his business structured, but he can either file for Chapter 7 or Chapter 13, one or the other. That's his only out of this situation. It just puts this particular case on hold until the bankruptcy is wrapped up. But in the end, it's going to cost him anyway. It's going to cost him his business. I'm sure he has other products other than Wrigley's trademark infringement e-liquids that he sells. So he's got to think to himself, is it worth filing for bankruptcy, giving up my entire business, or just recalling all these products and handing them over to Wrigley and then sending a report to the court saying we satisfied that. Anyway, I just wanted to share this with you. But yes, this is what matters. These are the things that matter. These particular situations is real. These are real. This is reality. This is not conjecture. This is not, something you make up, imagination, or for instigation, or starting trouble and all this other crap that's going on with these child appealing labels and all this other garbage. No, this is real. This is real, guys. This is a real thing. This is what matters. This is what a court will hear. Just want to share this information with you guys. Anyway, you guys have a good one. Bye.